What the Trump administration has decided is that that's not going to work. So last week, they announced that it was submitting a proposed rule to repeal the Clean Power Plan with no replacement. There are no goals to reduce carbon dioxide emissions, just getting rid of it. The justifications, they have to justify it both legally and or factually. The justifications was that it exceeds legal authority. And what the position the Trump administration has taken is twofold. First, that system of emissions reduction has to be what they call inside the fence. And it can't be outside the fence. And the fence being whatever fence is around that coal-fired power plant. So, the Trump administration claims those second two provisions, trade coal for natural gas or trade coal for solar and wind, are outside the fence, exceed the authority granted the EPA under the Clean Air Act, and thus are illegal. The second is they're saying it's not justified economically. There's like a one-page rationale for this. They promised to submit their economic analysis, and so I haven't seen it yet. But there already have been criticisms of it. It takes a different approach to the cost of carbon. The social cost of carbon is a big thing that we haven't yet pinned down. How much does carbon emission actually cost us as a society? It doesn't cause asthma. It's not like acid rain. It doesn't cause these demonstrable effects. And it might be that in Moscow, we don't notice them or won't notice them for a long time. Not the way that, say, Houston might have noticed them, right, more recently. So it's hard to determine what the costs of carbon are, and it's easy to disagree and affect these economic analyses. So that's what the Trump administration has done. As I say, the standards of performance for new or modified plants remain for now. This is not a big deal because we're not building new coal-fired power plants. And since we're not building new coal-fired power plants, new standards on coal-fired power plants really don't matter. Now, they will apply for major modifications to existing plants, but for the most part, and this is kind of the funny little tangent here, the coal industry, or the coal market and the power market has changed so much that the goals in the Clean Power Plan are going to be achieved anyway. Because we're not going to be producing new coal-fired power plants, they will be mothballed. They do have lifespan. So the most recent data suggests that on the ground it might not matter, but the market could change, right? It also signals something to the rest of the world. What are we telling China, for example? We don't have to do anything. We don't care about it. You don't have to either. So, not sure where that's going to go. Again, this is just last week, although there were signals that this was going to happen earlier. The second thing, and this one will matter here in a much more significant way, are these changes to the waters of the United States. These are prairie potholes up in North Dakota. Hugely important for migrating birds. This is one of the more important migration corridors, and one of the places that would not be protected under the revisions to the waters of the United States. So what is the WOTUS rule? It started back in the 80s. The courts alternatively agreeing and then disagreeing with the EPA and the Army Corps of Engineers' interpretations of what waters of the United States means. So after the 2006 decision Rapanos v. United States, which was a 4-1-4 decision, Scalia writing the decision for the plurality, the 4 on one end, Kennedy writing a concurrence in the outcome, in the what happened but not in the reasoning in the middle, and then 4 dissenters. It kind of threw the understanding of waters of the United States up in the air. But if you can do math, you have to get 5 justices, right? There's 9 of them. And everybody focused on the Scalia decision, but it's really the Kennedy concurrence that matters, because Kennedy's understanding of what waters of the United States are was agreed to by the 4 dissenters. You get the 4 dissenters and Kennedy, and that equals 5. The plurality that Scalia wrote, those 4 are off on their own. Scalia had a much narrower interpretation. So even though all the attention was paid to Kennedy's decision, there weren't 5 people that agreed with it. Only 4. 5 people that did agree with Kennedy. The 4 dissenters would have made it much broader. But they said, yeah, what Kennedy says is clearly is. And so what the EPA and the Army Corps of Engineers both have a jurisdiction over, in a variety of ways, over the waters of the United States. They had first done a couple of guidance documents to try to implement the Rapanos decision. And the court said, no, you need to come up with a real rule. And so the 2015 rule was intended to implement Kennedy's understanding of what waters of the United States means. And the phrase Kennedy had used was significant nexus to navigable waters. Scalia had argued that you need a permanent surface connection to navigable waters. That is, you need to see water flowing at all times, more or less. What Kennedy said is, no, there could be circumstances in which there's not a surface connection, but those kind of upstream waters do have an effect on the downstream navigable waters, whether pollutants flow into them, or they change the flow regimes, or whatever it is. And so you need to engage in this case-by-case analysis to decide whether those waters in fact affect the navigable waters. And if they do, then it's a water of the United States. And so that's what the rulemaking was intended to do. And it did two significant things. You read it today, and it's sort of sad that it's become such a big deal, because it's the exact same rule they had before with a couple little things added. And what those little things added were to define adjacent and neighboring, because the old rule had said adjacent waters are waters of the United States, and that had been upheld by the Supreme Court, actually. And that neighboring waters were waters of the United States, if they were adjacent to navigable waters or neighboring waters to navigable waters. So it created specific definitions for what that meant, actual distances, and then provided guidance on this case-specific significant nexus determination. So as you go about and figure out, do what Kennedy said, and the 4 dissenters said you need to do. Took, well, 9 years total to get it done, from the Rapanos decision to the 2015 rule. The EP and the Army Corps in 2027 published a proposed rule on June 27th to just trash the whole thing and go back to what it was before, along with the guidances that the court said were insufficient. Now, the reason they're doing this is because rewriting the whole rule would have taken probably both, if there were both, Trump terms, if there are to be two. It's a fantastically difficult, complicated process. So what they decided to do was, no, we're not going to do the whole thing, we're just going to repeal the old one, and then step 2 is to write a new one. So they're trying to repeal the old one just by saying the order is something like restoring federalism, the rule of law, and economic activity, or something like that. Basically saying it didn't follow the law. And there are a few little elements of it that might be problematic. The Sixth Circuit has already said that distances that were established weren't disclosed in the proposed rule, and maybe aren't an obvious outgrowth of the proposed rule, so there might be a problem with it. But for the most part, it follows, from my reading, it follows the Kennedy concurrence. The second step is going to be to develop a rule, and this is what the president said specifically, based on Scalia's Rapanos opinion. Write a rule that's consistent with what Scalia wrote. Which, of course, everybody who ever talks about this stuff knows that was only 4 people agreed with that. That is not what the Supreme Court thinks the rule is. So, if you had to predict, this might be successful. That is highly unlikely to be successful. We're going to waste another 10 years on this and then have it overturned by the court, and then the next president will get to figure out what to do with it. But significantly, this decision, this approach right here, would remove protections for olive prairie potholes. And if you go to Google Earth and you look at North Dakota, you can see how much water there is up there, lots of Minnesota. Would also remove protections for a lot of waterways in the west that are ephemeral or intermittent streams, but have significant effects downstream, because they could even be salmon habitat for that matter, but under the Scalia opinion would not be protected by the Waters of the United States rule. Can still be protected by state law. So, if you trust your state to step in and protect the way the fence would, that's okay too. Okay, then the final thing, the greater sage-grouse, and this one really troubles me for a lot of reasons. Not because it's such a cool looking bird, but because this was a really, really cool story. I love this story. So this is a very, very brief timeline, just to get us kind of where we are. So in 2005, the Fish and Wildlife Service had received petitions to list the sage-grouse as threatened or endangered. Has to do a review to decide whether it's warranted or not warranted. There's an intermediate warranted but precluded.